or community supervision with your attorney, did you understand it?
Yes.
And did you sign it? And each cause number, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictments as presented in cause number ending in 9-6?
No, Your Honor, state moves to waive the enhancement allegation as well as count 2 and proceed solely on count 1.
Any objection?
No objections.
And are you proceeding on the indictment as presented in 6-7?
No, Your Honor, state also moves to waive the enhancement allegation in that clause.
Any objection?
No objections.
All right, and each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
And cause number in 9-6, you're charged with fraudulent possession or use of credit card or debit card, 10 to 50 items as a second-degree felony, range of punishment. I'm sorry, you're only proceeding on one count, correct?
Correct.
Okay, it's just the way it's printed out. We're good though. All right, the range of punishment is anywhere from 2 to 20 years in prison. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, sir.
And each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront.
The judge is explaining the high stakes of deferred adjudication. It's essentially a probation first deal. But if she slips up, she doesn't get a trial. The judge can immediately sentence her to the maximum prison time.
Any witnesses, the state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes, sir.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Paez, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, sir.
If you're not a U.S. citizen, by entering into these pleas, you will be deported, denied naturalization, or reentry. Did you understand?
Yes, sir.
In each cause number, the court will find that defendant consideration 2025 CR 014168, 2025 CR 015020, and 2025 CR 015019. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State? In each cause number, did you review the waiver of appeal paragraph? Did you understand it and sign it in both places?
Yes, sir.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, have there been any such motions?
There are not, Your Honor.
And the cause number ending in 6-7 outside the agreement, there's to be no contact with Mission Mitsubishi at 9800 San Pedro, and there's to be no contact. Did you understand those were recommendations from the state, and the court does not have to follow that recommendation? Then in cause number, any witnesses, the state will call in the right to remain silent.
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony. Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, in each cause number, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Counsel, the state is opposed to your application. If you would like a PSI and a TAP evaluation, it'll be 8 to 12 weeks. If you would like it brought back sooner, I will listen to whatever witnesses or evidence that's submitted to me and make a decision.
Your Honor, after speaking with my client, we have a request if the court would consider signing the dismissals on the 3 cases that were taken into consideration in light of her plea.
The defense is trying to get her bond lowered so she can stay out of jail while waiting for the final sentencing. Judges are usually very cautious here, because once a plea is entered, the defendant becomes a higher flight risk.
Slightly reducing the bonds on the two that she's pled on so she can organize everything and take the full time for the PSI.
All right, so with regards to bond reductions, you'll have to file a motion and then I'll hear it so that the state can be prepared.
Okay.
And if the state is waiving no,
The court can say we're not going to accept the plea and that the full range is open. I believe that on its own will be sufficient to guarantee that she'll be here, and she'll, accept whatever the court decides at that point.
all right, so this is what I can tell you all. This is new to me. With regards to the court signing the dismissals. The signing of dismissals to the court appears to be a part of your plea bargain agreement. And until the plea bargain agreement is accepted by the court, which it hasn't been accepted, right? The only thing that I'm doing is memorializing for the record that this is your plea bargain agreement. I have not accepted it yet. However, again, it's novel to me. If somebody brings me some case law that says that the court can make a decision with its own discretion to dismiss cases if a plea bargain agreement has been entered to but not accepted by the court, I'll consider it. But my understanding of the law is that unless the state says they're in agreement to these cases being that is novel. That's the first time that's been brought. But if he brings me case law and says, oh, no, judge, it's within your discretion, then I'll hear it. Yes.
Your Honor, my client has decided to do not the full PSI. Will come back sooner rather than later.
All right, so let's go. We're back on the record. If you'll come forward. All right. So are you asking that the PSI be waived? All right. And then with regards to TAP evaluation, are you asking that that be waived as well?
Is it going to be the same wait time, Your Honor?
Vashon, how long is TAP just for a TAP evaluation? TAP evaluation is 4 weeks.
We'll do the TAP evaluation, Your Honor.
All right, so there is a request for a TAP evaluation. It's in both cause numbers. It's 2025 CR 014167 and 2025 CR 008396. All right, Ms. Ferguson, what date? Yes, and Ms. Abrams, if they can expedite that and maybe get it to us sooner than 4 weeks.
They're discussing a TAP evaluation, which looks at substance abuse issues. This is a key turning point because the results of this clinical assessment will heavily influence whether the judge picks prison or treatment.
We'll try.
I can do February 25th. Oh, I'm sorry, the 26th, Judge.
February 26th. And if for some reason, if they're able to do it sooner, they'll let your attorney know.
Yeah.
All right, you're welcome. Is there anything else?
Nothing for prevention.
All right, with that, we'll close the record. This is running concurrent with 2025 CR 008396. The state is taking in consideration 2025 CR 014168. Was there a plea on the 2025 CR 008396 case?
Yes, please.
Could I have the plea paperwork on that, please?
So
Yes, there are
defendant-
two cases.
Yeah, I'm sorry, I don't wrote down the one.
No problem.
What's the name?
Piaz, P-A-I-Z.
All right, and the court is also calling 2025 CR 008396 as well. And state, do you have any witnesses you're opposed? Defense, any witnesses you're opposed?
No, Judge.
All right, state, you're opposed. I'll hear your argument, but before we do that, for the record, in cause number 2025 CR 008396, there was a plea of guilty to count 1. The enhancement in count 2 was waived without objection. And according to the plea bargain agreement in that case, punishment is be assessed at 10 years in the prison. There's a $1,200 fine. This case is to run concurrent with 2025 CR 014167, taking in consideration 2025 CR 015020 and 2025 CR 015019. All right, the court will hear argument.
Opposed to Brian's application, we think she would be a good candidate. She's done 2 trips to prison in the past, but more importantly, crimes. She's had in her history of crimes of moral turpitude. She's also involved in people's information. Based on the TAP evaluation, it appears Ms. Paez is not motivated, and in the state's opinion, motivation is the biggest driving factor for someone to be successful on probation. So because of this reason, we asked.
All right, defense.
Judge, I spoke with Ms. Paez and she wanted me to speak, done for 5 years. She would like to ask the court for probation so she can get out and try to take care of her kids and give her a chance to get back on track and hopefully stay out of trouble. So I'd ask the court to grant her application for probation.
All right, is there anything you wish to say?
I would be.
Well, here's the thing, before you say anything, I would have to place you under.
This is a classic prosecutorial tactic. When a defendant uses their children as a reason for leniency, the state often points out that the defendant didn't seem to value those same children when they were out committing crimes.
And the state would have an opportunity to ask you questions. So do you wish to say anything? It's up to you. All right, can you raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, I'm gonna need you to speak up so I can hear and probation can hear. And so that the state can hear. All right, if you'll state your name for the record.
Melissa Renee Pice.
All right. Whoever wishes
Melissa,
to
what would you
proceed.
like to tell the judge about past witness?
Any questions?
Ms. Pice, you mentioned your children. Were you thinking of your children when you committed these offenses? No. How is the court to believe now that you're gonna use your children as motivation? I would be successful on probation.
I was grieving whenever I committed these crimes. My mom just passed away a year ago, this last month, just passed away. So I wasn't in the right frame of mind. with these crimes. I wasn't thinking about anybody. I was being selfish. Thank you.
I don't have anything further. Judge.
All right, I have a few questions.
Yes, ma'am.
So I don't understand how your grieving translates into your committing crime. And the reason why I'm asking, I'm trying to understand your thought process.
Hey, when my mom passed away,
Does anybody have any Kleenex over there? Okay.
admit that I just spiraled down just immediately after she passed away. Like I couldn't handle it. And then I needed help paying for my brother's bills whenever I got out because I was living with him. I rolled out to Viva, and I just got into something that was easy and it just stuck. And that's why I did it, because I just wanted to help, but drugs was never my addiction problem. It was the fact that I needed to help and I couldn't, but I was
So sorry, excuse me, miss, you're gonna have to take a seat. All right, you may continue.
I was grieving, and I can admit that I did start doing drugs, but like I said, drugs has never been my thing. So when I did that, it's just like when I got stuck doing that one thing on that drug, that it just kept going from there, and I just kept
And
going.
where were your children doing all of this?
They were my father-in-law. But my father-in-law again was telling me that I couldn't get back into my children's life until I was stable, and I understood that, but again, I was grieving and I started doing drugs.
R 014167. Court is gonna find you guilty. The court will sentence you to a $1,200 fine. Time and money will run concurrently. Court will request the therapeutic community. This will run concurrent with 2025 CR 008396. Take in consideration 2025 CR 014.
In the end, the judge lands on a 9-year sentence, but includes a therapeutic community requirement. It's a middle ground approach, holding her accountable with a felony conviction while still mandating the help she claims she needs.
6-8. There's to be no contact with, I'm sorry, state you may be excused. There's to be no contact with Mission Mitsubishi at 9800 San Pedro. And Charlene Hill. There's to be no unsupervised contact with minors. And the court will sentence you to 9-year conviction. You're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. In cause number 2025 CR 008396. The court is going to find you guilty. Court will give you credit for any time served. Court will sentence you to 9 years in the prison. 967. Taking consideration 2025 CR 015020 and 2025 CR 015019. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal? And I'm sorry, the court is also going to order the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. The therapeutic community is designed to help